everybody's attention. Professor Jessica Roberts is the director of the Health Law and Policy Institute and the Leonard Childs Professor in Law at the University of Houston Law Center, where she specializes in genetics and the law, health law, and disability law. She is a noted expert on diverse issues of health law with scholarship focusing on the intersection of health law, ethics, and social justice. Today, she will be presenting materials on technology and health.
Thank you so much. So good afternoon, everyone. I hope you're enjoying your lunch. I just wanted to take a moment to thank our organizers, especially Jalen, Jared, and Professor Blake. And I'm honored to be part of this symposium on such an important issue, and I'm very sorry that I could not be there in person with you today. My talk is about health apps as a way to address rural health disparities. And I will advance this. Excellent. So here's a quick overview of some of my remarks for this afternoon. I'll open by explaining some of the causes of health disparities, including in West Virginia, to demonstrate why we need greater accessibility and affordability in healthcare. I'll then turn to health apps as a potential remedy. I'll say a little bit about what health apps are and why they're beneficial. Then I'll consider the drawbacks of health apps with respect to their privacy and their effectiveness. And I'll give you all a few examples of recent controversies to demonstrate why we should be concerned. And then I'll end with next steps. First, the roles that agencies currently play, and second, what remains to be done. So here we go. So rural health disparities. Given the topic of the symposium, I won't say too much about existing disparities, as I'm sure many of you are already familiar, and other speakers are also going to touch on these issues or already have this morning. Specifically, rural populations often experience greater incidences of disease and worse health outcomes than people in more populated areas. And while there are numerous factors that contribute to these inequalities, I want to focus on two here: healthcare access and the ability to pay. So I will start with access. One reason that people in rural communities, including here in West Virginia, experience health disparities is that they have difficulty accessing healthcare in the first place. So this map shows how healthcare providers in the state tend to cluster into certain areas, which requires rural West Virginians to have to travel farther to access needed healthcare. So that is one way. Another thing for us to consider is the ability to pay. Cost is another important contributor to health disparities. Because so much of healthcare in the United States is expensive and requires patients to pay either through benefits or out of their own pockets, there's an inverse link in this country between poverty and health. Sadly, that means that even if rural West Virginians manage to access healthcare, they may not be able to afford it. So my question for today is, can health apps help? But before we can answer that question, we need to answer an important preliminary question. What are health apps? And the answer to that is they are in fact a lot of different things. Health apps are a very big market and it's only growing. So there's over 325,000 healthcare apps that are currently available for download, and an estimated 52% of smartphone users already collect health information on their phones. In fact, many of you here today may currently be health app users. For example, I am a health app user. I have some examples of different types of health apps here. This is definitely not an exhaustive list. This is some health apps that I've written about, but here you can see some examples of femtech apps, mental health apps, and genetics apps. Now, a lot of things fall under the health app umbrella, so other examples of health apps might be even COVID tracking apps, right? So that's arguably a type of health apps. And I would say health apps broadly defined are smartphone apps that provide users with information related to health and wellness. And they include highly regulated technologies that qualify as medical devices and allegedly low-risk wellness apps. And I'll say more about why that's significant later. As I mentioned, common examples include fertility trackers. They also might include meditation apps, apps that sync with wearables like Fitbits, Apple Watches, or digital blood pressure cuffs. Basically, anything that you have on your phone that relates to your health and collects your information. So why are these things beneficial? In fact, I believe that health apps have a lot of different potential benefits. To start, even for non-rural populations, American healthcare is notoriously expensive and difficult to access. Many other populations, such as people of color, trans people, and people with disabilities, also experience health disparities. Yet over 80% of Americans own a smartphone. That means that health apps could give users access to health-related information and services that they would otherwise lack. Health apps may also give users access to more accurate and reliable information in some contexts. Research shows that people may be more candid with technology than they are with other humans. So you might be more willing to tell your health app something than your actual doctor. And because of the constant and long-term use of health apps, they collect more individual health data over time than would be available from sporadic physician visits. Imagine a digital blood pressure cuff that you use to take your blood pressure every morning in your home, opposed to only getting your blood pressure taken for your yearly checkup. But despite these benefits, health apps also raise concerns related to privacy and effectiveness. So what are these concerns? And I mentioned I'd give you an example of some different controversies. And the thing to keep in mind is that health apps can warehouse significant amounts of highly sensitive data, making their users vulnerable to potentially devastating privacy violations. I'll go back to those 3 examples of different types of health apps I mentioned earlier. So when you're talking about femtech apps, they can collect information that relates to things like fertility, sexual activity, vaginal discharge. If you're talking about mental health apps, those might talk about or might collect information about feelings of self-worth, subjective mental state, and even suicidal ideation, or information that is genetic in these genetic apps could relate to health, familial relationship, or ancestry. And all of these things I think are pretty private, and we might not want third parties to know about them. So the users of health apps may understandably want to keep the data these apps collect private, but the health app companies themselves have different ideas. So last year, the Federal Trade Commission settled a complaint against the period and fertility tracking app Flow. Flow collects its users' data to make predictions about when they will ovulate and menstruate. And as mentioned, some of this data is extremely, extremely intimate, the kinds of information that people input to predict ovulation and menstruation. And not surprisingly then, Flow promised its consumers that it was going to keep that information private, away from the prying eyes of third parties. However, a 2019 expose in the Wall Street Journal revealed that Flow had been sharing its users' personal and identifiable data with marketing and analytic firms, including Facebook. And the social media platform was in turn using that information about these individual users to target advertising to them based on whether a user had her period or was trying to conceive. Now, Flow users reported feeling outraged, victimized, and violated by this. Flow, like many other health apps in this booming industry, was touting its privacy in its promotional materials, as well as in its terms of service and privacy policy. And Flow users felt that the company had promised them one thing and done another. The FTC used its authority to police unfair or deceptive trade practices to hold Flow accountable. Its complaint alleged that Flow made repeated deceptive statements to its consumers. And as part of the company's settlement agreement, Flow agreed to have a review of its privacy policy and promised to obtain user consent before sharing data. So that's one example of a potentially devastating privacy violation by a health app. Here is another. More recently, the nonprofit organization Crisis Text Line raised eyebrows by sharing its data with a for-profit affiliate. So what is Crisis Text Hotline? Well, people who are in the midst of a mental health crisis can text a number and be connected with an AI-based chat service. The chat service first obtains consent and then, based on a user's responses, pairs them with a live crisis counselor. The organization keeps transcripts of these chats, which it has called the largest mental health data set in the world. It consists of nearly 200 million messages. Just last month, it was made public that the organization used a for-profit spinoff to generate and market customer service software drawn from the AI in that data set. Although the charity claimed that any information it shared was fully anonymized, the announcement nonetheless generated public outcry, including from the volunteer counselors who staff the service. And while not a smartphone app per se, Crisis Text Line is yet another example of consumer health data that is highly, highly sensitive, getting commercialized and without the knowledge of users. So those are 2 examples of privacy violations. What are some of the effectiveness concerns? Health apps can raise effectiveness concerns by not actually doing what they claim to do. And I have some examples of these as well. So in 2011, the FTC took action against 2 health apps that purported to treat acne. The apps told consumers to hold their phones against their skin for a few minutes each day so the apps could emit alternating red and blue light. According to their marketing materials, the apps could cure acne, they were created by a dermatologist, and they were supported by scientific evidence. Of course, you will probably not be surprised that none of this was true, and certainly holding a dirty smartphone to your face is not good for your skin. So the settlement agreement here prevented the app developers from making acne-related claims, as well from misrepresenting science. And here's another example. This one might be familiar to you all. You can consider Luminosity, the brain training app, which you may recognize from a few years back. Luminosity initially claimed that it could improve cognitive function, delay age-related cognitive decline, and reduce cognitive impairments associated with several different mental health conditions. And the app advertised that scientific studies backed up these claims. But again, the evidence did not support these assertions. The FTC brought an action against the developer, and Luminosity also ultimately settled and changed their practices. Right. So those are the kind of effectiveness concerns. So on one hand, apps might share your data without letting you know and commercialize it, and that data is highly sensitive. And secondly, these apps might not even do the things that they're telling you that they do when you download them. So this raises the question, where do we go from here? And as I mentioned, the first thing I think we have to consider is whether or not agencies can help. And I have some examples of some federal agencies here. And you might think that the Department of Health and Human Services might be able to police health apps through the Health Insurance Portability and Accountability Act, or HIPAA. HIPAA covers healthcare providers, health plans, healthcare clearinghouses, and their business associates. But despite offering health-related services and collecting health-related information, many apps do not actually provide healthcare per se in the legal sense. Direct-to-consumer health apps frequently include medical disclaimers. So legally speaking, health app users are consumers, not patients. HIPAA would apply to a health app offered through your doctor, but not to these readily downloadable direct-to-consumer apps that I've been focusing on today. So that means the exact same data could get different privacy protection. HIPAA would protect the date of a person's last menstrual period in her medical record, or even on my chart, but it would not protect that same information when stored on a femtech app. Also, too, if you store your medical records on a third-party platform like Apple Healthcare or Google Health, they could actually lose their HIPAA protections. Of course, they could be subject to other agencies' oversight like the Federal Trade Commission, which I'll discuss momentarily. So HHS can't do a lot for us here. But what about the FDA? It regulates medical devices, which can include software. And I said that at least some of these apps qualify as medical devices. Why isn't it doing more to prevent some of these things from happening? And the reason is, again, that most healthcare apps can escape regulation. So some health apps, like an app called Natural Cycles, have voluntarily sought FDA approval, but most of them qualify as these low-risk wellness apps, and they don't require FDA oversight. There's a carve-out in the 21st Century Cures Act for software intended for maintaining or encouraging a healthy lifestyle and is unrelated to diagnosis, cure, mitigation, prevention, or treatment of a disease or condition. And this is because these apps are considered to be low risk. The FDA dialed back its oversight even further over the course of the pandemic with respect to mental health apps. It issued guidance in April 2020 stating that it didn't intend to enforce actions against what it called these low-risk apps if they didn't create an undue risk in light of the mental health, in light of the public health emergency. So the idea was so many people were in crisis because of the pandemic that the FDA was going to give mental health apps a little bit more leeway to allow people to use them to improve their health. So the bottom line is that most health apps are consumer technologies and not medical devices. But luckily, we do have an agency that is responsible for protecting consumers, the FTC. And as my examples show, the FTC is working to help protect health app users. The FTC protects consumers against anti-competitive, deceptive, and unfair business practices. And the agency has taken some action to better regulate privacy and to better regulate the effectiveness. And recently, the FTC has issued guidance for the health breach notification rule, which could mean greater privacy protections for consumers. Although it's not gained much attention until recently, the health breach notification rule has been around for over a decade. It's an FTC regulation designed to reach health data entities that are not covered by HIPAA, so exactly things like apps. And its goal is to ensure that consumers know when their health data has been compromised to empower them to take steps to secure their data and protect their identities. And in September 2021, the FTC issued a policy statement explaining that the health breach notification rule applies to wellness apps and requires them to notify consumers in the event of a breach. But this guidance caused controversy because some commentators believed that the guidance didn't simply clarify what the health breach notification rule was doing, but rather expanded what it does. And in fact, 2 commissioners believed that this was something that was too expansive and actually voted against the policy statement. And the vote was tellingly 3-2. But regardless of what happens with the health breach notification rule, at present, the FTC is probably in the best position to regulate consumer health apps. However, several important gaps remain. We can start with what we can do to better protect consumer privacy. You might think that it would be enough to just encourage people to read the terms of service and the privacy policies, and that would generally be a step in the right direction. However, these terms are often difficult to read or navigate. The companies could ensure that the materials are at an 8th grade reading level, which is the reading level required for informed consent, and that the tech presents the terms in a way that is more likely the person will read rather than just scroll and click. Additionally, many companies reserve the right to unilaterally amend their terms of service and privacy policies, so even if consumers shop for privacies, they will not be safe. For example, if Flow wanted to legally break its promises, it could have stopped advertising privacy and simply changed its terms of service to allow data sharing. So what can we do about this? Well, one option would be to pass a federal data privacy law or consumer protection law. Congress could pass something akin to the General Data Protection Regulation in the EU, and it could fill some of the gaps. And it could also make sure that entities that handle data would be subject to certain standards, including governing norms like lawfulness, transparency, integrity, and accountability, and operational guiding principles, things like minimizing the data that they collect to the things that's necessary for collection, ensuring accuracy, and preventing subsequent use, that is secondary use of the data. We could also restrict the ability to make these one-sided changes that could allow data sharing to better protect consumer health data. The law could require apps to get consent for material changes that could harm users. And this is actually something that I and co-authors have written about. And we've said that these one-sided changes are actually really damaging to consumer privacy in the context of health apps. What else could we do? The FTC could step up its regulation. Certainly a federal data protection statute could give the agency greater authority to issue rules or guidance, but even without a data protection statute, the FTC could take action. For example, it issued this policy statement related to the health breach notification rule. It could use its ability to make rules and issue guidance. Congress could also devote more resources to the FTC to allow it to be a more effective consumer watchdog. And beyond enforcement, the FTC could do more things like education, promoting consumer awareness, offering advice to companies about the best practices. Now, for the concerns related to effectiveness, we need to do more to allow users to distinguish between reliable products that do the things that they say they do and what is the digital equivalent of snake oil. And my colleague at the University of Houston, Leah Fowler, has been thinking about this issue, and she has a few suggestions. First, she suggests introducing an evidence label that would require health app developers to make explicit claims about the scientific evidence that supports their product and its uses. And this is something that would appear when you're looking in the App Store and give you information about whether or not the app is supported by scientific evidence. And an evidence label, as she proposes, would include at least 3 elements: what the app does, how it does it, and what evidence supports it. And secondly, she suggests ensuring that the information contained in the evidence label is readily available to users at the point of download. Something interesting that you might not know is that the App Store currently makes no efforts to distinguish between app quality and effectiveness in the order it displays apps to potential users. Star rating, I think, plays a factor, but that's user information and not anything that speaks to the app's actual ability to do what it says. This is just sort of user perception. So under Professor Fowler's proposal, she thinks the evidence label should affect where an app appears in the list of search results. Something you might not know is that people are much more likely to pick the thing that appears first or relatively early in the list. And so she thinks it would be a useful nudge to make sure that the most reputable apps are listed first. So that would increase the chances that a consumer is going to select a reliable product. So it is my hope that with the help of these interventions, health apps could fill the healthcare gaps in rural America, not just cheaply and easily, but also safely and effectively and without compromising consumer privacy. So thank you so much for your time, and I look forward to your questions and to our panel.
All right, Professor Roberts, we're going to take some questions from the audience. So does anyone have any questions?
Can you hear me?
I can, yeah.
Well, first, thank you for taking the time out of your day to do this presentation, and look forward to hearing you more in the symposium. My question goes to, in rural communities where there's low health literacy and then also low technological literacy, how are health apps going to bridge the deficient outcomes we're seeing in rural communities, or are they going to exacerbate this problem?
Okay, so I think this is a great question. And the health app literacy, so the ability of health apps to address any health disparities has to deal with health literacy issues. And I think that this is why it's really crucial on the sort of legal and regulatory side to make sure that these apps are clear and that they do what they purport to do, right? And so if you have a low health literacy, you might not be interested in the context of the evidence label, right? So you might not want to like click on that and see, what peer-reviewed study ends up supporting the claim of the app. But it in fact will if you just go into your phone and you type in mental health apps. Right now, the most popular app might come up, or I don't even know what they use in the algorithms to list them. But the idea of having a vetted app appear first really, really would increase the chances that the person is getting a good product, because we're relatively simple. We really do pick the thing that comes up first. And so it would be my hope that if the apps are better regulated, both with respect to agencies and within the industry, right? A lot of this is industry practices, to make sure that the terms of service and the promises that they make are clear. They're written at an 8th grade reading level so that people can understand them, and that we have, that they're supported by evidence, that we wouldn't exacerbate, and that these could actually be really useful tools, since rural Americans also have cell phones and it's easier to, track health and perhaps get help. For example, if you think about the crisis text hotline, it might be easier to use your phone than it would be to actually seek help. Does that answer your question, maybe? I think the best we can do is nudges and clarity. And I think that that's something that benefits all consumers. Yeah.
So I'm going to ask a quick question, and thank you again for speaking with us today. I kind of see sort of almost like two categories of the health apps being, one being apps that are really putting people in connection with providers,
Yeah.
with therapists, providing that kind of telehealth services, and then the apps that are sort of almost like Headspace that are kind of just walking people through meditation and stuff like that. So have there been any sort of regulations that are trying to separate between the two, or has it really just been sort of like health apps are sort of being treated as they're under this kind of just one umbrella?
Yeah, and I have to say, one of the things that was interesting when I was prepping for today is I was talking to some of my colleagues that also write in this space, and I was like, who has a good working definition of health app? And I gave you one that I made up. Because these really do include a lot of different things, and they provide a lot of different types of services. And so, and the way the industry sort of divides itself up with the different kinds of products it offers doesn't correspond really neatly to the sort of regulatory lines about what we regulate and what we don't. And the truth of the matter is, a lot of these things, like these apps that want to gain FDA approval, well, they can go and get it, but that is a very, very small percentage of all of the apps in the total market. And I will just admittedly say that I'm a privacy and anti-discrimination scholar. I'm not an FDA scholar, so I can't answer questions really about the fine details about, which, what makes an app be FDA approved. What I know is that the apps that get approval from the FDA are the ones that go and seek it and say that, you know, we want to be able to tell consumers that we are FDA approved for birth control. So that's what Natural Cycles did. It went out and it said, you know, we are going to show that there's science to back it up, that this is something that people can use reliably to, you know, predict menstruation and fertility, and you can actually use it as birth control. Now, in the universe, there are a bajillion other types, other varieties of, or very similar products that use different tech that are not reliable. In fact, Professor Fowler, when she was written a lot about these femtech apps, and one example that she likes to show is there's like an app that purports to somehow link your menstruation to the cycles of the moon, right? And if you look up femtech apps, the moon cycles app shows up alongside the natural cycles app, right? And so it is really the Wild West out there. And while there are these different services, there's not a lot of great legal or regulatory differentiation between them. It's hard because I can't see people's faces, so I don't know if I'm making sense to you guys. But yeah, hopefully that answers your question.
Yes, thank you so much. That was great.
Any other questions from the room? All right, seeing none. Hold on, I'm going to move over. All right, we're not seeing any other questions, so we're going to go ahead and take a break. We will reconvene at about 1:15 with our Appalachian Health panel, and we will see you then, Professor Roberts. Thank you.